Essentially, I think we're all pretty familiar with the issue, which has come back a number of times in various guises, which is when people are granted pre-settled status, if they then make a benefits claim and they don't have a right to reside in the context of the old EEA regulations, which based on the Free Movement Directive, the DWP says that you have no access to benefits unless you either get a right to reside or you qualify for settled status. So it leaves people in difficult situations if they can't prove essentially that right to reside. And obviously the arguments of some of them have been along the lines of essentially that there are discrimination clauses within the withdrawal agreement which require equal treatment, and once a person is granted pre-settled status, they are being granted withdrawal agreement status, and therefore they have the right to be treated equally with UK nationals, which would effectively remove that right to reside test when they make certain benefits claims. The case that was heard in a case that was brought effectively on a pre-transition, when we were during the transition period, that was looked at, that situation was looked at by the Court of Justice, who came back in this decision of CG, which is heavily referenced in this current upper tribunal decision. And the difference with the upper tribunal decision in AT, which was brought on by CPAG, is that the claim or the refusal of the universal credit was done after the end of the transition period. And so a lot of the arguments of the DWP related to the fact that once the transition period had ended, the situation had changed, and specifically the situation in respect of the Charter of the Fundamental Rights, or the EU Charter of Fundamental Rights, which is what the CG case said did apply to people with pre-settled status when they looked at the pre-transition or the period in the transition period. And so effectively AT argued that her scenario needed to be looked at within the context of the Charter of Fundamental Rights as it continued to apply as per the withdrawal agreement. It was agreed that she didn't have a right to reside, as I understand it. So it was particularly about, I have been granted pre-settled status as a domestic provision, but because of the case in CG and the application of the Charter under the withdrawal agreement, I must have an assessment of my Charter rights, which the DWP said, no, the Charter no longer applies because it's the transition period has finished, and that removed any reference to the Charter from the UK's perspective. The judgment really effectively followed the judgment in CG and said the withdrawal agreement explicitly sets out elements of the Charter that continue to apply in decisions that fall within the ambit of EU law, and that's important because it has to be a decision that would be judiciable as an EU law decision rather than a domestic decision. And so there's a lot of discussion about whether the decision was an EU law decision, because of whether or not AT was essentially a beneficiary of the withdrawal agreement. Had she found to not be a beneficiary of the withdrawal agreement, presumably the decision would have been different. But the upper tribunal said, because AT has come to the UK under free movement when it applied, she may not be here under the conditions of the Citizens' Rights Directive, but she does have the protection of the withdrawal agreement, because the withdrawal agreement says that someone who has entered the UK under EU law is, before the end of the transition period, is protected. I think that part of the decision is probably the most complicated to get your head around, because it sort of creates lots of concepts of different types of beneficiaries of the withdrawal agreement, as far as I can see it, and so it is quite a confusing aspect of it. But essentially, for the practical impact on people's lives, the point is, someone who is an EU national or a family member of an EU national who's entered the UK under free movement law and has been granted pre-settled status even if it's on the more favourable terms that the UK has operated their settlement scheme under, they can argue that they are a withdrawal agreement beneficiary, and therefore a decision that affects their charter, fundamental charter rights, needs to be made in accordance with the charter. And that's when, so having found that was the case, the court then moved on to assessing what did the charter require, and again with reference back to the CG case, and what it was effectively was that where someone is being refused, in this case universal credit, but social assistance, has the DWP carried out an assessment on their facts, the facts of the individual facts of that person's situation, about whether that refusal would breach their charter rights, and within this is a specific reference to the right of sort of to dignity, and then the rights of sort of children attached to that. And because the DWP hadn't carried out an individual assessment, except to say that we think that there are other types of support you may be able to access on either on a statutory or discretionary basis, then that's good enough for us to think that you're not going to be in a situation where you don't have the right to dignity. And the tribunal said, no, that's not enough of an individual assessment, and it does need to be carried out on their specific facts with reference to their specific situation. And if you're saying there's support available to them, it has to be genuinely and realistically available to them, to avoid a potential breach of the charter. And then the last part of the decision was the upper tribunal agreeing with the first tier tribunal that the facts of or AT specific situation meant that she did not have access to enough support, genuine support, that would not breach her fundamental charter rights. So everything went against the DWP. The whole thing went against the DWP on every point. So it's a really strong decision in that sense. And as I understand it, and Martin probably wants to come in here, but the DWP are not going to lie down. They've challenged it, and it will be heard, and I think it's going to be rolled up with some other decisions on the charter to do with housing assistance as well.
So the Secretary of State has appealed. We didn't oppose them getting permission actually from the upper tribunal on some of the things on which they got permission. The appeal has now been filed with the Court of Appeal. It's due to be heard immediately after, as Chris mentioned, these other cases about the charter and housing assistance. So hopefully we will keep that slot and it'll be heard on the 9th and 10th of March. But it's undoubtedly, whichever side wins, going to be further appealed. It'll either the Court of Appeal will think, well, this isn't clear and refer it to the Court of Justice, or it'll go to the Supreme Court, which should, if nobody else has refer it to the Court of Justice. So it's going to run and run. And for those not familiar with Social Security, there are, the normal principle is people are entitled to rely on the law as declared by the courts, even whilst there's an appeal pending, and it would be in the discretion of a court to decide whether to stay your case, your client's case, whilst our appeal is pending. The legislation for Social Security contains a number of provisions collectively known as the anti-test case rules, which basically allow the Secretary of State to just not make decisions on any case where the Secretary of State is of the view that his decision might be different if he was to win his appeal in our case. So what the Secretary of State is actually doing in those cases is, in every single case where the Secretary of State thinks you haven't got an old immigration EEA regs style right to reside, but you have got PSS, the Secretary of State says, I just put you on my file, I'll decide your case later. So effectively, and if you challenge, also if you've had a negative decision saying you don't have a right to reside and you want to challenge it, the Secretary of State can't immediately say, oh, you do have a right to reside, I got that wrong. Secretary of State will say, but I won't decide your challenge until the proceedings in AT are finished. So effectively, that puts a complete stop on claimants' ability to challenge right to reside decisions, and also to take advantage of the judgment in AT whilst the litigation is pending. There is a massive caveat to that, though, which is that the Secretary of State's power to stay an individual case, to put it on the pile of one he's not going to decide, is a discretionary power. And the Secretary of State's policy on when to use that discretionary power is not to do so if to do so would cause hardship to your client. Now, it's an interesting mental experiment to think, what's the overlap in the Venn diagram between someone who would be at a risk of a breach of their dignity, breach of being able to live here in dignified conditions, if UC is not awarded to them. So that means the court held that means would be at risk even for a temporary period of being without basic necessities, food, shelter, sanitary items, accommodation which is adequately heated, right? So there's a risk you're going to be without those things, and then you're in hardship. The only potential case of someone who's not actually in hardship without UC is like, oh, I've got enough money for the next month or something like that. It will be very few cases. So the question of whether the Secretary of State, first of all, you can ask the Secretary of State to unsuspend, to unstay your case. If the Secretary of State fails to unstay your case, then there's a challenge by way of judicial review to that decision. But there may also be a more general challenge by way of judicial review to the Secretary of State's general policy of staying cases, because arguably, like there are no cases where stay would be appropriate, because everyone who could benefit from AT will be in hardship if you don't give them UC. That's what the judgment in AT requires, more or less. So yeah, it's a bit of a mess. We really, we had the experience when we ran Fratilla. We had a victory in the Court of Appeal. Obviously, ultimately, the Court of Appeal decision was shown to be wrong by the decision in CG. But, there was a 6-month period where nobody benefited from the fact that the Court of Appeal had said the right to reside test was unlawful for everyone. We really don't want that to happen with this case. Obviously, we don't want to lose, but if people are destitute without universal credit, there are things they can do at the moment. So that's the kind of high-level takeaway. We'll have on our website, certainly before Tuesday, templates for things like getting cases expedited in the upper tribunal, drafting witness evidence in order to show that you meet the test in AT, pre-action letters for templates for when you're put on the stay pile and you shouldn't be. And so we'd urge you to use those, and we're happy to take questions, by email about whether your client could benefit from it.